Hi, I'm attorney Greg Dell here with attorney Rachel Alters, and we're going to talk about the Standard Insurance Company and how to handle a lawsuit against the Standard once all administrative remedies have been exhausted, which means the claimant who's watching this particular video has already filed all their appeals. They received that letter that says, "We're sorry, we don't agree with you, we don't think you're disabled. ERISA allows you to file a lawsuit. Good luck." So they're trying to figure out what to do. We'll talk in this video about our experience, which is basically that we've handled hundreds of lawsuits against the Standard all over the country, been to their offices in Portland to depose various people there, know all about the ins and outs, their claim handling procedures and everything. We're able to represent the claimants all over the country. So obviously after 20 years of doing this, we know exactly what Standard's doing. But let's give the person the roadmap. They got the letter. What are the first steps we're going to take once they engage us to help them?
Well, once you receive the letter that says no more appeals, you've exhausted all your administrative remedies, you contact our office and you retain our services, and we will send a letter of representation to the Standard letting them know that we represent you. They are no longer at all able to contact the claimant at all. They can only go through us. And then we request the claimant's full claim file, which is basically every medical record, every claim note, anything that was in the administrative record, so that we can review it and see why the Standard has denied the claim. And once we request that claim file, we go through it, very carefully to see what the reasons were, the doctors that they hired, the peer review physicians, anything IMEs that they sent, so we know what they based the denial on. And then we go ahead and file a lawsuit in federal court.
Right, and we rely on that information in the claim file to make a detailed complaint so that we get all of the allegations in, and then we move forward from there. So a person watching this, in most situations, was on claim and got denied.
Right.
And so they went through the 180 days of appeal plus probably 90 to 120 days that Standard took to make a final decision.
Sure.
They've been without benefits for at least 6 to 9 months, if not longer. And they're wondering, how long is this going to take? When and if am I going to see any money?
Right. And unfortunately, it's not a quick process.
Okay.
So you file the complaint with federal court, and the defendant, the insurance company, the Standard, has 21 days to answer. And then they usually ask for an extension, and oftentimes we do grant it as a courtesy, so they'll ask for a 2-week extension. So by the time they get their answer in, it's probably 45 days. Once they get their answer in, if we don't have to respond to a counterclaim, because often they will file a counterclaim for if there's an overpayment from any kind of Social Security disability payment. If we have to file an answer, then it adds a little bit of time. Then the judge will enter a scheduling order. And the scheduling order will consist of when motion for summary judgment is due, when mediation deadline is, and a trial date, usually.
Okay. In terms of scheduling orders, when is usually a trial on average set in an ERISA disability claim?
Some of the judges lately, I've noticed, are fast tracking them, and it can be set within 6 months of the date of filing the complaint. Other judges, it's a year out. It depends on how busy their docket is, but oftentimes we do see them fast tracked. And when that happens, it's often better for the claimant, because then we get a mediation date quicker. We can send out a demand quicker and try and get it resolved in a faster timeline. Otherwise, the insurance carrier really has no, incentive to quickly review the file.
Right, so I often tell claimants expect 6 to 12 months and we should have the claim resolved. Now, there's multiple remedies in these lawsuits that can come out, but the reality is that 98, 97% of them resolve in what's called a lump sum settlement.
Right.
Why is it that 97% of these cases are resolving with a one-time payment as opposed to going the distance and going to verdict?
Well, it depends on, it's a case-by-case scenario, so every case is different. Some cases are stronger than others. Unfortunately, there's a law called, ERISA, which is the Employee Retirement Income Security Act, which was, basically enacted in 1974 to supposedly protect the claimants, but it really does protect the insurance company. And the laws are written in favor of the insurance companies. The scales are tipped in favor of the insurance companies. So it is hard to actually win these cases sometimes, and you have to prove in the court that the insurance carrier, such as Standard, was arbitrary and capricious in the denial of the claim, which basically means in layman's terms that they didn't even have one reasonable basis to deny the claim. And it's hard to prove that, because if they hire one of their hired guns, who Standard has their own staff of medical doctors who review medical records, and in their opinion, they state that there is no, that the person is not disabled and that the claimant's able to do their job, the material substantial duty of their job, and they disagree with the treating doctors, that could be considered a reasonable basis. So it's, pretty hard, and often these federal judges will rule in favor of the insurance carriers. So oftentimes they do, 97% of the time will come to a lump sum settlement for what, that's one of the reasons. The other reason is that best case scenario for a claimant, if they win their case, is they're going to get past benefits. They don't get any future benefits, ongoing. It gets kicked back to the insurance carrier to make a determination if there's still an ongoing disability. So oftentimes, if it's just past benefits that are going to get paid, it's not really worth it to go through the entire cycle again to possibly get denied and have to go through an appeal process. So oftentimes a lump sum settlement is the best case scenario for the claimant.
Right, and then the other thing is, it comes down to, I like to use this example, that if the policy is worth $200,000 through all the payments and what's owed to you, and they offer you $75,000,
Right.
you then make a business decision. Yeah, I understand I'm not getting the $200 that I could get, but if I go to trial, there's a risk I get zero, and the
Right.
best case scenario, I get back on claim, which may not even equal $75,000. It might only be like $30,000 at that
Sure.
point. Then I gotta hope they keep paying me. So I'm trying to go from 75 to 200,000, and I'm just basically, I'm betting. I'm basically saying, I'm hoping that I can invest 75,000 in this claim and maybe end up with 200,000. So
Right.
you have to take a real practical approach. There's a lot of law firms out there who want to push a quick settlement because they want to get quick money, or they may not want a claimant to take a settlement because the lawyers can get paid $300, $400, $500, even $700, $800 an hour to proceed with a case to go to trial, and they're going to make a lot more money than they might make on a settlement. So that's not where our focus is. Our focus is, let's look at the risk versus reward,
Right.
and whatever's best for the client. But I want the clients to feel comfortable knowing that if we have to go the distance, we will.
Sure.
But let's not blow smoke and say, oh, we're going to fight them, we're going to go tooth and nail, we're going to go all the way to the court, because the case law is what it is, and the case is only as good as the appeal you did and how they reviewed the file.
Right.
And if 80% of these cases are being won by the defense, that means it's going to be very difficult most of the times to win this case, but yet, because of us fighting them through all these cases and all these years, whether it's them or everyone else, they know that we're one of the leading firms who do this. They're going to spend tens of thousands of dollars fighting this.
Of course.
And they're possibly going to lose their case. So if we accept your case, we're going to get an offer. The question is how much and what percentage of the total is that going to be? And if you want to go the distance, we will go the distance. So
Right.
no matter where you live in the country, we're available to help you. We always offer a free consultation. We're never going to charge you any fees or costs unless we make a recovery for you, which means that if we lose your case, you don't owe us anything, you don't owe us the costs. And if we do win the case, it's a percentage of your benefits that you receive, and then we'll continue to represent you and protect your claim if it doesn't end in a lump sum settlement if you were to get on claim. So
Right.
give us a call. The only thing we need is you can also click the free consultation on our website, which will go to one of our lawyers and we'll call you right away. Or you can call us now. We're going to ask you to send us a copy of your denial letter. We'll review it, and within a matter of minutes, Rachel or any of the other attorneys here will let you know immediately how we can help you. Thank you for considering us, and we look forward to speaking with you.